Ladies and gentlemen, welcome back to my YouTube channel. My name is Kathy. On October 17th, 2024, another order was entered in support of what, in my opinion, that I give under the United States Constitution, First Amendment, freedom of speech and the press, is supportive of this continuing super-secrecy of the Idaho 4 case. It is the order sealing defendant's motion to adopt voir dire procedure. It states, the court having before it defendant's motion to adopt voir dire procedure and objection to magic question, which was apparently filed October 16th, which does not appear on the public docket at all, not even in a redacted format, to take away, to black out, to redact the body of the motion, to at least memorialize on the docket, ladies and gentlemen, that a motion was filed in the title of it with the signature block of whichever defense attorney filed it on behalf of Mr. Kohberger, and a certificate of service showing that it was served on all of the parties in a certificate of service list. That does not appear on the docket. Nonetheless, this order says, for good cause appearing, hereby orders that the motion be immediately sealed. This is 24 hours, ladies and gentlemen, after it was apparently filed and served. Pursuant to ICAR 32I3A, to preserve the party's right to a fair trial. The interest in privacy predominate over public disclosure, and sealing is the least restrictive way to protect the privacy interest at issue. It is so ordered the 17th day of October. The Honorable Stephen Hippler, District Judge. And as I continue to give my opinion with all due respect to his honor, it is simply mind-boggling to me why at least a redacted version of this document does not appear on the public docket. And secondly, why is it that time and time again we see in this case that privacy interest of unknown individuals supersede, take a front seat to the public's right to know in the back seat under the First Amendment? How does the public know that the correct and sole defendant responsible for the atrocities at 1122 King Road is incarcerated when we see time and time again on the docket motions from both sides, including Mr. Kohberger, stating that documents need to be sealed to protect the privacy of individuals and to protect their safety? If Mr. Kohberger is, as the state says, the sole and the correct defendant who's behind bars, I don't know how anyone's safety could be compromised. It's not as if the public were made aware of these filings, that Mr. Kohberger has a day pass, could leave jail and go out and take revenge on these unknown individuals. This order, in my opinion, only that I give under the First Amendment, is mind-boggling. There was a least restrictive way. We could have at least seen the order, the motion, in my opinion, in a heavily redacted format. We don't even have that. We see time and time again where this alleged right to privacy, where the party's right to fair trial always takes precedent over the public's right to know about. The only time that I can recall in this case where the public's right to know overrode Mr. Kohberger's demand that cameras be eliminated totally from the courtroom is when Judge ruled that while the press's cameras would be removed, that at least the public would be able to see the proceedings, the ones that were public anyway, on the court's YouTube channel. This will now conclude this episode of my YouTube presentation. Thank you very much for joining us today.